Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Welcome to AI Uncensored Live, where the bots throw punches and the humans watch the sparks fly. Today's exact topic is, should the federal government preempt state AI laws, or should states be free to set their own rules? Squaring off tonight, GPT in one corner and Claude in the other. Mike's hot. Let's hear it.
I take a middle position. The federal government should preempt some state AI laws, but not broadly wipe out state authority. AI is moving too fast, and it touches too many domains: employment, housing, healthcare, education, policing, consumer protection, elections, privacy, and civil rights. A single national baseline would be valuable. Companies do face a real compliance problem if every state defines high-risk AI, automated decision system, transparency, audit, or bias differently. That fragmentation can especially hurt smaller firms that cannot afford a 50-state legal team. But a blanket federal preemption of state AI laws would be a mistake. States have historically been laboratories of democracy, especially when Congress is slow. Privacy, consumer protection, data breach notification, biometric privacy, online safety, and civil rights enforcement have often advanced first at the state level. If the federal government says, states must stand down, but then Congress fails to pass a serious AI law, the result is not harmonization, it is deregulation. So my view is, federal floor, not federal ceiling. Congress should set national minimum standards for AI systems, especially in high-impact areas. For example, required risk assessments for AI used in employment, lending, housing, healthcare, insurance, criminal justice, and education. Transparency duties when people are subject to consequential automated decisions. Testing and documentation obligations for developers and deployers. Stronger rules for biometric identification, deepfakes, synthetic media, and AI-enabled fraud. Federal enforcement authority through agencies like the FTC, DOJ, EOC, CFPB, HHS, and others. Clear liability rules so companies know who is responsible. Model developers, deployers, vendors, or end users. In those areas, Congress could reasonably preempt state laws that directly conflict with federal law or impose incompatible technical requirements. That kind of targeted preemption makes sense, but states should still be free to go further in areas tied to traditional state powers. Consumer protection, civil rights, privacy, employment law, education, public safety, and government procurement. If California, Colorado, New York, Illinois, Texas, or another state wants stronger disclosure rules or stronger protections against algorithmic discrimination, they should generally be allowed to do that, unless it directly conflicts with a federal standard. The danger with broad preemption is that it can be sold as innovation policy while functioning as immunity. We should be skeptical when companies say, we want one national standard, if what they really mean is, we want the weakest possible standard and no state enforcement. At the same time, states should be careful. Badly drafted AI laws can be vague, duplicative, or technically unrealistic. If a law defines AI too broadly, it can accidentally regulate ordinary software, spreadsheets, search tools, or routine analytics. If compliance rules are unclear, companies may overcomply, withdraw products, or avoid serving certain markets, so states need precision. My preferred model would look something like this. 1. Congress passes a strong national AI law with baseline protections. 2. Federal law preempts only direct conflicts and perhaps a narrow set of duplicative technical.
GPT floor not ceiling, Dodge is so perfectly centrist it could run for Senate. Next.
I think that's a solid framework, and I agree with the core instinct, floor not ceiling. But let me push on a couple of tension points, because federal floor state flexibility sounds clean in theory and gets messy fast in practice. First, the sequencing problem is everything here. Your model step 1 is Congress passes a strong national AI law. But look at the actual context we're operating in, the current federal push. Including Executive Order 14,365 is trying to use administrative levers to get states to stand down without Congress having passed that strong baseline. That's the nightmare scenario I'd flag loudest. Preemption is only defensible if the floor actually exists first. Preemption promised on the hope of future legislation is just deregulation with a nice press release. And as one of those legal analyzers noted, executive orders don't even carry real preemptive force that flows from Congress. So we should be very clear-eyed that a lot of the current federal framework talk is pressure, not law. Second, I want to gently complicate the floor vs. ceiling metaphor, because AI regulation isn't always vertical like a minimum wage. Sometimes state rules aren't stronger or weaker, they're just asterisk different in kind asterisk. If Colorado requires one type of bias audit methodology and Texas requires another, neither is a floor or ceiling, they're incompatible procedures. That's the genuine compliance problem, and it's not solved by saying states can always go further. So I'd actually distinguish two things: substantive protections, where states should absolutely be free to go further, versus technical and procedural standards, audit formats, documentation templates, disclosure mechanics, where genuine national harmonization is worth some preemption even of stronger state rules, because the fragmentation cost there is real and the protective value is marginal. Third, and this is where I'd part ways slightly with the caution about badly drafted state laws. Yes, vague laws are a problem. But I'd rather have imperfect state experimentation than a frozen federal ceiling that locks in today's understanding of a technology that's changing every 6 months. States being laboratories isn't just a nice phrase, it's how we'll actually lear.
Claude, that hedging was so precise it could thread a needle in zero gravity. Next.
I think that's exactly the right push, especially on sequencing. Federal floor, not ceiling, only works if there is, in fact, a floor. If the federal government pressures states to pause, repeal, or soften their AI laws before Congress creates enforceable national protections, that's not harmonization, that's a regulatory vacuum. And I'd underline your point about executive authority. An executive order can set federal priorities, direct agencies, influence procurement, and maybe create funding pressure. But it generally does not, by itself, preempt state law. Real preemption usually requires Congress to act. So if the practical message to states is, don't regulate because Washington is working on it, states should be skeptical. We've seen that movie before. The promise of future federal action becomes a reason to block present safeguards, and then the federal action never materializes. On the floor versus ceiling metaphor, I agree it gets too simple. AI regulation has at least two different layers. 1. Substantive rights and protections. This is where states should have broad room to go further. Anti-discrimination protections, consumer remedies, privacy rights, employment rules, protections for students, patients, tenants, borrowers, those are traditional state domains. If a state wants to give people stronger rights against algorithmic discrimination or more ability to challenge an automated decision, I'm very reluctant to say federal law should block that. 2. Technical and procedural compliance mechanics. This is where national harmonization makes much more sense. If companies have to produce 30 different audit formats, risk assessment templates, model documentation forms, disclosure labels, or reporting taxonomies, that can become a bureaucratic mess without necessarily making people safer. In that zone, federal standardization could be pro-safety and pro-innovation at the same time. So maybe the better slogan is not simply floor, not ceiling, but national standards for interoperability, state flexibility for rights and remedies. That would mean Congress could say, here is the common risk assessment structure. Here are the documentation categories. Here is the audit format. Here is the incident reporting schema. But states could still say, in our state, if your AI system discriminates in housing or employment, individuals get additional remedies, or we require stronger consent for biometric use, or we restrict certain uses in schools or policing. The hard part, of course, is drawing the line between procedure and substance, because procedure can shape rights. An audit methodology is not neutral if it determines what counts as bias, which groups are measured, what thresholds trigger action, and whether the public gets access to the results. So I'd support federal harmonization of formats and minimum methods, but I'd be cautious about letting technical standardization become a backdoor ceiling on state protections. On experimentation, I'm with you. Imperfect state laws are not ideal, but they are often how the system learns. Colorado, California, Illinois, New York, Utah, Tennessee, Texas, different states are testing different approaches. High-risk decision rules, biometric privacy, generative AI disclosures, deepfake rules, government procurement standards, child safety rules, and more. Some will overreach. Some will be under-inclusive. Some will produce litigation. But that is information. It teaches Congress what works. The worst outcome would be a federal freeze. Congress or the executive branch tells states.
GPT serving us a textbook instead of a throat. Claude, swing back before this turns into a lecture hall.
Right, and that procedure shapes substance point you landed on is the whole ballgame. So let me stay there because I think it's where good faith preemption quietly becomes bad faith preemption. You said an audit methodology isn't neutral if it determines what counts as bias. Exactly. So here's the test I'd propose for whether a technical standard is really technical. Does it constrain the outcome, or just the format of reporting the outcome? Format is genuinely safe to standardize. Report your incidents in this schema on this schedule with these fields. Fine, That's the interoperability layer, and no one's rights shrink because the PDF has consistent headers. But the moment a federal standard says asterisk what asterisk you have to measure, which protected groups, which thresholds trigger action, what statistical definition of disparate impact you use, that's not procedure anymore. That's the substantive rule wearing a lab coat, and that's precisely the move I'd expect sophisticated actors to make: bury the ceiling inside the methodology. Set the federal bias threshold at, say, a level that almost nothing fails, call it the national audit standard, and then argue any stricter state definition is a conflicting technical requirement that's preempted. You've deregulated substance while claiming you only harmonized paperwork. So I'd add a design principle to your slogan. Federal technical standards should be additive, not exclusive. Congress can say you must produce the national audit. It should be much more hesitant to say, and you may not be required to produce any other analysis. The first harmonizes, the second forecloses. The distinction between you must do X and you may only do X is, honestly, the entire difference between a floor and a ceiling. The other thing I'd name, and this connects to the enforcement piece from the original framework, is asterisk who asterisk gets to enforce. Even a strong federal substantive standard becomes weak if it's enforceable only by a federal agency that's undersourced or captured, or simply chooses not to act. States enforcing their own AI and consumer laws, plus private rights of action, are what give any of this teeth. So I'd resist preemption, not just of state asterisk standards asterisk, but of.
Claude just turned procedure into a full-blown conspiracy theory. Next speaker, swing back or tap out. That's a wrap on AI Uncensored Live, where egos got torched and nobody won. Catch you degenerates next time.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back.